Hi everyone, this is Pennsylvania attorney Evan Gutman here with video number 20 of my video legal education series, which addresses the good moral character requirement to obtain a law license. The full book is available on my website, my two websites actually. One is gutmanvaluations.com and the other is heavensadmissions.com. Both websites also contain a supplement to the book that I wrote a few years later, as well as a fictional novel I wrote titled Heaven's Admissions Process, which is kind of a fun, humorous novel that compares the criteria to be admitted into heaven with the criteria to obtain a law license on earth. It's a fun book. You should also have access, if you're taking a look at this on Facebook, to links for a PDF file that correlates with video number 20, which is what this is, as well as each of the other videos. There's a link to a PDF. The videos are also available on YouTube. My YouTube site is titled Judicial Constructive Criticism Network. My Facebook pages are my personal page, and then I also have a separate Facebook page titled Judicial Constructive Criticism Network. So here we go with video number 20. This video is actually part 2 of chapter 19 of my book, which is titled, Can the Judiciary Withstand Scrutiny Under Its Own State Bar Admission Standards? The State Bar Admission Standards in general encompass positive character traits and negative character traits. And the concept is that the applicant is supposed to exemplify the positive traits to obtain a law license. If they exemplify the negative traits, they don't get a law license. And they're essentially the opposite of each other. The positive traits are truthfulness, candor, honesty, and complete disclosure. The negative traits are the exact opposite: non-disclosure, false disclosure, evasiveness, or misleading disclosure. Now, in video 19, I address examples where the judiciary does not meet its own standards with respect to these traits. And now in part 2 of video 19, which is video 20, I know it's a little confusing, but this is part 2 of chapter 19. I'm going to address some more areas where the judiciary does not meet its own criteria of honesty and fairness. The first one I'm going to address is just a basic thing that courts quite often do. Quite often the judiciary, particularly in U.S. Supreme Court opinions, to justify their overreach of power, they assert that the judiciary is the weakest branch of government, and therefore is supposed to be kind of above it all, not political, and that it was the third branch of government, so it needs to be given a little more leeway and deference than the other two branches of government. The fact of the matter is that's a completely false statement, a false and misleading disclosure, and it doesn't meet the State Bar Admission Standards. The reason is the judiciary has the sole and exclusive power, at least currently, may not in the future, but currently it does have the sole and exclusive power to interpret the law, and once you can interpret the law, you can say it is whatever you want it to be. The words drafted by the legislatures mean nothing once you can interpret the law however you want. The second manner in which they have the most power is that they license the attorneys who appear before the courts, whereas every single other profession, medicine, accounting, engineering, dentistry, people are typically licensed as professionals by agencies that are enacted by the legislative branch or executive branch. The attorneys are the only profession that the judiciary licenses, and that gives them control over pretty much anything, because once you have control over a man's livelihood by his license, or a woman's livelihood for that matter, you basically control everything that's going on. Second one for today is an interesting case. It's an Oregon case from 1991, and it's titled State of Oregon v. Balfour. That's Balfour. It's a 1991 case. And in that case, a criminal defendant wanted to raise issues on an appeal that his attorney refused to present because his attorney felt they were frivolous. But it's the defendant who was going to be going to jail or suffer the other consequences. So I always believe a litigant should be able to assert the grounds for their position, maybe with a little bit of control being exerted by the attorney representing them. But for the most part, if a litigant wants a ground presented or an issue presented, I believe it should be presented. And in the case, the Oregon Supreme Court, in its opinion, which denied that right, in its case, the Oregon Supreme Court made a quite unprecedented and incredible statement of overreaching authority about U.S. Supreme Court opinions that addressed this issue. The Oregon Supreme Court wrote as follows, if you can believe this. They wrote, quote, "Thus, we are neither bound nor relieved of our own duty in the matter by the United States Supreme Court's prior estimation of the proper ethical course of action for an appointed attorney who concludes that only frivolous issues exist for appeal." Thus, the Oregon Supreme Court is quite forthrightly saying, we don't have to listen to the U.S. Supreme Court. U.S. Supreme Court can take a hike if we're the Oregon Supreme Court deciding otherwise. That's a very unprecedented opinion. It's basically spitting in the face of the U.S. Supreme Court. And when state Supreme Courts do that, it can be fairly well predicted that state court of appeals will say they're not bound by state Supreme Court decisions. Trial court judges will say they're not bound by appellate decisions. So once everybody's doing what they want to do and just ignoring opinions, the system, the legitimacy of the system kind of collapses. Certainly, judges are not too pleased when attorneys or litigants say, I'm not bound by your court order, judge. And quite often those court orders are legally invalid and therefore void. But if you don't follow them, you got a problem. The next issue I want to address is what I call, and this is in chapter 19 of the book, paragraph 24, which is numbered. I titled this, "The Games Judges Play Cannot Sustain Scrutiny." What am I talking about, the games judges play? Let me give you some examples. Intentional delay by a judge on ruling on a motion happens all the time. If you're a litigant or an attorney representing a litigant, you're supposed to file a document within a certain specified period of time. If it's an answer in a lawsuit, maybe you have 30 days to respond. Maybe the rule says you have 20 days to respond. But the bottom line is you have a certain number of days. If you're filing an objection to a motion, quite often, most often, there are time frames within which you need to file that objection. The objection must be filed within 15 days, for instance. So litigants have to, and their attorneys have to file documents within a certain period of time. Judges have no limit. The judge, when a motion is presented and then say it's opposed, the judge can render his ruling the next day. He can render his ruling 6 months from then. He can render his ruling 8 months from then. So by controlling the time frame in which the judge rules, whereas litigants cannot do that, litigants have to file things within a certain period of time, by giving the judge unlimited discretion into how far in advance they can rule or how quickly they can rule, they can really control the litigation outcome and leverage the parties by making the party they don't like wait a year for a ruling, and the party they do, quote, like, gets their ruling within 1 day. So the manipulation of time by trial court judges is a game they play that fails scrutiny under basic moral character standards of fairness and equal protection, as well as due process. Similarly, along with that exact same concept are the scheduling of hearings. The judge can order a hearing immediately. The judge can basically say, we'll have a hearing on this 8-9 months from now. So by manipulating the time frames of when hearings are held, the judgments quite often grant postponements to avoid ruling. They don't want to rule on the issue. It's a tough issue, and the litigant I don't like is right, so instead of ruling, I'm just not going to rule. I'm just not going to rule at all. And by doing that, they're largely being cowards and chickens. That is my position. Basically, the concept of postponing a ruling because you don't like how the ruling would be, because the litigant you don't like is right, that's very deceptive and nefarious in my view. The other game judges play, it's what I call the judicial pocket veto. I think I came up with that myself, actually, that title. Whoever came up with it, it's great, and I use it. But I call it the judicial pocket veto. And what the judge does with the judicial pocket veto, he rules on a motion. He rules on a motion within a proper time frame. But he then delays issuing the written order reflecting his ruling. So maybe he'll say on a phone conference call or at a hearing, I'm going to rule in favor of so-and-so, but then they don't enter the order. Or they enter the order, and this has happened too, I've seen this. They enter a written order, but they just decide not to serve one party with it. They only give the order to the other party. That does happen, and I've seen it happen. The judicial pocket veto is often utilized by judges to give a party the judge likes a lot, to give them extra time to plan a counterattack against an opposing litigant who the judge dislikes. So they're doing a lot of things based upon whether they like or dislike the litigant that really are not within the proper constraints of fairness and impartiality. Another one of my favorite games, and I use that term favorite in a somewhat sarcastic manner, the judicial tactic of ruling without ruling. Now, what do I mean by that? Ruling without ruling? Well, quite often what a judge will do, in order to encourage parties to settle a case, the judge will have a conference on the case between the two attorneys. And the litigants most often are not there when the conference is taking place. This is just between the attorneys because they want to keep the whole thing in-house. And the judge will say, well, you know, if I were to rule on this, I'd rule in favor of party A. But I'm going to hold off on ruling. I'm going to hold off on ruling for now. But I will tell you right now, if I were to rule, I'd rule in favor of party A. Now, why does the judge do that? He does it to encourage settlement of the case because he doesn't really want to rule. So what he does is he indicates how he would rule if he were going to rule, with the concept being that party B, who's been told that party A would win if the judge rules, party B then goes to his client, the attorney goes to the client and say, I think the judge is going to rule in favor of the other side, so you better settle. The concept of judges effectively leveraging the parties into settling is not in conformity with basic mandates and dictates of fairness and impartiality. The litigants are there to litigate. The judges are there to rule. And the concept of ruling without ruling, once again, in my view, is a cowardly chicken manner for judges to perform their duties, or I should say, not perform the duties they're supposed to perform. Another aspect that I'm going to go into right now is members of the public are under a misconception that juries decide cases. Juries don't decide cases. As a matter of form, it's written down that they do, but the real outcome of most cases is really determined by the judge. And the reason for this is as follows. The judge controls the evidence that the jury sees. The judge controls what evidence is admitted and what evidence is excluded. And once you control the evidence that the jury is seeing, for the most part, you're really controlling the litigation outcome. All you got to do is, if you don't like Party B, exclude their evidence. If you like Party A, let all their evidence in. The last item that I'm really going to address, where courts are quite basically misleading at best, is we've all heard at one point in time or another, ignorance of the law is no excuse for violating it. In other words, a citizen is presumed to have knowledge of all enacted laws. And if you violate those laws, you're basically responsible for paying penalties, sometimes incarceration, for your violation of the law. The concept that judges are saying ignorance of the law is not a valid excuse, while perhaps a necessary component of society, and it might be perhaps a necessary component of society, but the fact of the matter is that ignorance of the law is not a potential issue, it's a certainty. Because since judges are interpreting the law, one does not have to look very far where one judge says, this is the law, and another judge says, no, that's not the law, this is what the law means. Appellate opinions are rife with appellate justices saying we should affirm because the law says this, and then you have a dissenting opinion that says, no, the law does not mean that. The law really means this. So if judges themselves are ignorant, quote, ignorant, judges themselves are ignorant about what the law is, suffice to say, citizens without any legal training quite often have a very, very valid excuse, particularly when you're dealing with laws that deal with intricate procedural issues. They have a very valid excuse for having ignorance of the law, and perhaps they should be excused. I say perhaps, but by the same token, there is some validity to the concept that if you just said ignorance of the law is a valid excuse, everybody would just say they're ignorant of the law, so they should be let off, and you can't do that. But nevertheless, judges are being quite misleading on the issue when they hold otherwise. Anyway, that's today's video. We'll have the next video up within the next 2, 3, 4 days, maybe 5. But I hope you enjoyed it. And remember, love right, don't fight. Bye, everybody.